Are you ready for an exclusive? Gina Carano has just added major legal firepower to her team, funded by Elon Musk, and you must know who this person is. But that's not all. Ron Coleman joins us as well, and he says this is a case that could go all the way up to the Supreme Court of the United States. Buckle up, folks. Click the like button. It's time. Well, it is not a swell day for Kathleen Kennedy, and we are here to tell the tale. Folks, as we get ready to dive in, be the gigawatts we need. Like and subscribe. We're going to have a real good time. Ron Coleman is here with us. He's represented President Trump before. Now he has thoughts before we head into the trial with Gina Carano, Star Wars, Kathleen Kennedy, and more. Here we go. Ron, we've got a legal mountain that's happening as Gina Carano continues to climb the slopes, taking on the dopes at Disney, and there have been some changes. So, Jonas, why don't you put up on the screen what those changes are, and then we're going to get Ron's thoughts on this. This is one of those things that I'm not sure, well, definitely the legacy access media has no idea what to do with it, but I'm not sure that anybody yet really knows what's going on here, and Ron's going to help us understand it a bit.
All right. So I was perusing through some legal filings the other day, otherwise known as getting signed up for notifications on Court Listener. I just want to point out this document in the United States District Court of Central District of California in the case of Gina Carano v. the Walt Disney Company. This document, called a pro hoc vice, no relation to anyone on the panel here, was filed designating Eugene Volokh as someone who is going to act as a representative in this case. Now, Ron, what is pro hoc vice, and who is this man?
Pro hoc vice is Latin for this cause, meaning for purposes of this case, Judge, I'm asking you to permit me to appear as if I were admitted to the bar of this court. And these applications are routinely granted for lawyers of good standing from other jurisdictions. I myself have been admitted to the Central District of California many times because that's where a lot of the fun litigation takes place. Even I'm not admitted in California, but I say, hey, I'm admitted in New York. I'm admitted in New Jersey. There are pending disciplinary problems involving my license, and I would like to be allowed to represent this client at his request or her request. So the more interesting thing than my explanation of the pro hoc vice is who the pro hoc vice representative or attorney is, and that's Eugene Volokh. Eugene Volokh is a law professor, a very well-known one in conservative and libertarian political circles, very highly respected. He has a website which used to be found at Volokh Conspiracy. It's one of the last remaining really active political. It now lives on the reason.com website. There was a short period actually where it was on the Washington Post website. That was not a good match. But a lot of the worthies of the law professoriate of the right participate in discussions on Volokh Conspiracy. A lot of them are my friends. I know Eugene. I would think it would be presumptuous of me to say that he's my friend. Not that he's my enemy, but I do know him, and we've been on many cases together. Here's what's fascinating about this. We've discussed the legal issues in this case many times, and there's a California statute, as we recall, that is at stake here. This is not a case that could have been brought in almost any other state that I'm aware of, because you don't have a right to be employed or to remain employed by any company merely by virtue of, let me restate that. In every other state, as far as I know, you can be fired for expressing your opinions, even not in connection with your work, unless it's a public employer. And I think that most of us who've ever started or owned a business appreciate that. If someone that I hired ends up having obnoxious views, I don't want that person to be associated with me anymore. California passed a statute to protect communists 75 or something years ago. I think it was in the 50s, early 60s, called the Unruh Act, because so many communists were involved in Hollywood and still are. And it said you can't fire someone because of their expression of political opinion. And that's an interesting policy, completely legitimate policy. And that's the policy that our friend is suing under. It is not the kind of policy I would necessarily expect a libertarian law professor to be in favor of. So I find it very interesting that he's getting involved in this case. I don't know what the intention is, or what motivated Eugene, but it is, again, we're talking about policy choices. This is the beauty of federalism. Different states can choose to do things different ways within constitutional limits. You might have expected Eugene to come into this case not representing Gina Carano, but representing Disney. Not that he is a friend of big corporations as such, but you might well think a libertarian law professor would take the position that Disney should be able to hire or fire whoever, fire whomever they want. And we're sure, right, that he is coming in to represent Gina Carano?
I believe so. This is filed as part of the Gina Carano case.
Yeah.
And looking at the Pro Hoc Vice request here, it does say Carano v. Disney on it. I've brought that up on the screen here. I can blow it up, but you're on a phone.
Well, blow it up. No, I wouldn't mind if you would blow it up, because it's important to know exactly which side he's going to be representing.
Well, if
purpose to appear on behalf of Gina, on that very bottom line. Yes. I mean, you and I both looked at this before we recorded, but all of a sudden it's so, let's put it this way. It's so amazing to me that he's coming in on this side that for a moment I had a little bit of a crisis of confidence. Is this really happening? So, no, it really is happening, and that's really what it is. He is representing Gina Carano, even though, again, you might think that as a libertarian, his motive, his point of view is companies should be free to hire and fire. I'm really looking forward to seeing, if it's discernible, how it is Eugene is going to affect the briefing and argument in this case.
Ron, how big of a deal is this in terms of superstar status within the legal world? Is this a huge shift in the way that we should approach this in terms of, I guess, recognizing the importance from the legal side of it? Like, do you think the movers and shakers of the country now have looked at this and said, "Whoa, wait a minute, there is an opportunity to really claim some ground"?
I would say that, movers and shakers might be a little bit beyond my pay scale, but I do think that influential people in free speech and constitutional law must be talking about this. And I really should have picked up the phone and spoken to some of them who I do know, to ask them what their take is on this. It's a big deal. It's something that's going to be noticed. Let's be clear. Gina, as we've discussed many times, already won the motion to dismiss, which is gigantic. It's going to end up being appealed. Disney tried to get a shortcut to appeal, and they were denied the opportunity for an immediate appeal. Ultimately, if there's not a settlement, this is going to go to a final judgment. There will be a summary judgment at some point. It's interesting that Eugene is coming into the case at this point, as opposed to on appeal, or as opposed to at the motion to dismiss stage. So, but it's going to be noticed by the judges. The judges know who he is and what his reputation is, and it would seem to me that there's a different tack that is going to be introduced in this case by virtue of Eugene's involvement in it. I think it's very exciting.
Now, there's one other question I want to ask, then I'll open up the panel to send you in commentary and questions. But Ron, the schedule right now has this thing going to trial in March and April of next year, which would put this coming out. The trial would be ongoing at the same time that the big movie, the next Star Wars movie that Gina would presumably have been in, will be in theaters. Do you think that is a reasonable timeline, or do you think that this is an obvious to people who are in the legal profession? Is this an obvious situation where it's going to be delayed past that point, and we're just all here as lay people thinking, oh boy, the stars have aligned, and we're just, ignorant?
It's a reasonable timeline, especially in California, in the Central District of California, which really manages it very efficiently. It's arguably a rocket docket. In New York or New Jersey and many other courts, because there is inevitably going to be a summary judgment motion here, I say inevitably, 75% likelihood. I can think of reasons why there might not be, but it's beyond the scope of this discussion. But given the high likelihood of a summary judgment motion, you might think that the schedule would be put on ice until the court decides the summary judgment motion, because you can't really prepare for trial when a summary judgment motion is pending. In California, however, they turn things around pretty fast, and the period for making a summary judgment motion and for the judge to make a ruling on it is probably pretty firm. In terms of the facts in this case, putting aside the speed at which courts themselves move, there's no reason on earth that discovery cannot be completed and trial prepared for by early next year.
Wow. Well, listen, we would love that. I mean, that would be that is content gold if the Star Wars movie and the Gina trial are happening at the same time. We can only pray that the Baldoni and Amber Heard 2.0 situation, Blake Lively, we're talking about you, comes to be at the same time. Panel, go ahead and get your questions in to Ron while we've still got him. I know he's on a short timeline here, but we'd love to get your cues in as well.
Well, do you think this noteworthy attorney is joining the case because of how much this might upset the established order in Hollywood? I mean, with the Unruh Act being, basically law in the books for as long as it has been, and for allowing, corporations to I don't know, the idea that you could actually be fired over these issues, I think is why a lot of people in Hollywood don't actually speak out. And this would upset all of that. Do you think this is why this notable attorney would be joining this case?
I think that's I think he's, let's broaden it a little bit. California matters for lots of reasons other than Hollywood. And I would not be surprised if, rather than being concerned about the most privileged people in the world, he and his friends, I would imagine, see this as a case that goes to the issue of individual liberty. The Unruh Act happens to be, as I said, a facet law school hypothetical, because you have this balance of property rights versus individual rights, and one of Eugene's main interests as a libertarian and conservative law professor and writer is free speech. There's no question that regardless of how you assign property rights, you're definitely going to come out on the free speech side if you're under the Unruh Act. It makes it easier for people to take part in public debate if they know that they're not going to lose their jobs. So I think you're onto something. I think that, again, I would love to hear a further articulation from Eugene himself, and I certainly don't want to presume to speak for him, but I think you're on the right track.
Hey, Ron, Elon Musk is funding all of this, we believe. That's what's been stated in the past. Not sure if he's funding the additions to the team, but I'm just curious, have you heard anything behind the scenes in regards to Elon and whether or not he has made connections now with the free speech advocates at the highest levels? Has he, because he's very much in favor of a free discourse online, and he's perhaps one of the most important figures in our lifetimes for safeguarding free speech. But I don't know that his circle has extended, into this realm of people who are fighting the legal battles for it. I don't know if you've heard anything in that regards.
Well, he certainly is funding the litigation. Let there be no question about that. Is he also paying for, is angry at me for
Ron, we actually, that's some of the best action we've had on the show all day. The steering wheel going back and forth. I can't get Jonas to even move on the show. So thank you, Ron.
Yeah, that's a good point. I don't know beyond that. I mean, I can tell you, I guess I really can't tell you. I do know that this is something that is affirmatively being managed and addressed by Elon's team, but I personally haven't been in touch with them since I left the Dylan law.
Well, now, Ron, lest we go too far and push too far, you tell us if we can't go there. But you're saying that you were in contact with Elon Musk and perhaps some part of this effort back when you were with Dylan.
Yeah.
Okay. We won't go any farther than that. We'll leave it there. Yep. Let me get. Okay. Culture I was about to go to Culture, and he's just disappeared. Jonas, I'll let you do the follow-up question, and then we'll take any questions the audience might have with Ron.
Well, to me, this is all fascinating, and I'm lucky enough to have been able to ask Ron separately. And I'll say the first thing he said when I sent this to him was fascinating, or very interesting. Here on this, this is the kind of guy that if he's, I don't think he'd be taking the stand in this instance. So this is not an expert witness that they're going to put him on the stand and then have the other side cross-examine him and try to say, well, Mr. Expert on free speech and the Constitution and all of this, what about our rights here? Which, that's the classic Disney defense in this place, because I think it's Dan Petroselli that's on the other side of this, and he has one button that he likes to push, and it is the free speech button.
And he also was pro hoc vice on the Florida case. You asked about pro hoc vice before. That's how he was able to be lead attorney on that.
Yeah. So I guess my question is he's only he could potentially only be acting behind the scenes as a consultant on this. Well, I guess he wouldn't have to do that.
Here's the thing: if he were doing that, he wouldn't need to be admitted pro hoc vice. He would simply be part of conference calls, or and email trails. So pro hoc vice means I'm going to practice law.
So does that mean he's going to be in live court? They're actually questioning
that it means that is a distinct possibility, or that he may argue a motion or submit something under his own name. And again, there are lots and lots of legal papers that are written by people that you don't know who they are. And sometimes it's even me, and they're not part of a case, but someone's helping out or whatever the case may be. And I don't think of Eugene as someone who's obsessed with having his name out there. He's, I don't think that's necessary to him.
Canceled.
There you go. I'm being canceled. Um, I would say that some kind of there are two possibilities. Either Eugene is going to participate in the argument of a motion, and I probably should have taken a look at the docket to see if there are any upcoming motions that would implicate these issues. And why don't I promise to do that and get back to you guys, and maybe we'll do a discussion about that. Or it would surprise me if he appeared on behalf of Gina just to send a message. That strikes me as probably it's not, I think, Eugene's kind of move. So I think you're going in, actively involved in some substantive legal discussion.
So does this, if I'm reading this as a case that has a high likelihood of setting precedent, especially in California, would that be one of the reasons they could incentivize one of their affiliates to come in and actually act pro hoc vice to I mean, this could be a historical ruling for that district in California. Am I mistaken there?
Well, you're not only not mistaken, but you're understating it, because it's going to be appealed, again, assuming no settlement. It's going to go up to the 9th. And once it goes up to the 9th, that's going to Ninth Circuit. And there's a very good possibility that it goes up to the Supreme Court. Now, as far as I know, Disney has not and presumably does not intend to, has not put forward a defense that the Unruh Act itself is unconstitutional. I'm not sure whether they reserved their ability or preserved their ability to raise that later. I would have thought that if they were going to argue that, they would have argued it on the motion to dismiss. There are many good institutional reasons for them not to do that, because it would make left-wingers unhappy.
Yeah, I would think so.
But
you want to preserve that. You want to preserve that in court. That's why you want to get it on the record. First and foremost. Is that what you're saying, Ron?
Well, you can preserve it as a defense without necessarily using it as grounds for a motion to dismiss.
Oh, I see. Okay.
So yeah, it could go all the way to the top. And the real question is, I suppose, are there issues here that threaten the Unruh Act, and B, go beyond the Unruh Act, which I think is by far the more interesting question. Do we set, because the entire concept of cancel culture and doxing is premised on this idea that you're going to make it impossible for someone to remain employed because he has spoken incorrectly. And people on the right wing do this also. This person who acted like, a beast to someone because of, some kind of woke sensibility. We want to get, not me, Ron Coleman, but there are rage mobs on the right as well as on the left, and people try to get people fired. What if that were not allowed to work anymore?
Right. The idea of societal excommunication. Ron, so that we can help the journalists, the drive-bys, get tomorrow's headlines down on paper. You said something that
listening to us.
You said something that they're going to be interested in, and that is regarding the Supreme Court. So I just want to get you clearly on the record for them as they get their jumbo pencils from kindergarten ready. Ron, you're saying that the Gina Carano case is a strong candidate for a case that could appear before SCOTUS. Is that right?
It's got legs. It definitely could happen. Yeah.
All right, ZZ Top. I hear what you're saying. All right, panel. Any other questions for Ron before we keep moving?
Well, the only thing I would ask is, so on the off chance it does make it through the Ninth Circuit in the whole nine, and we do end up at the Supreme Court, the real risk here would be completely eliminating that law, right? It's unconstitutional. And if this happened because of Disney, Ron, how do you think their popularity would be in Hollywood after that decision?
Well, it's an interesting question, because the Unruh Act, let's face it, it is not a case of speaking truth to power to criticize anything or anyone on the right anymore. I don't know how much the left in Hollywood needs the Unruh Act. I don't think, yes, I do think they don't want to be the ones holding that smoking warm gun if it is found dead in the pub. But right now, it's probably more of a burden than a friend unless Gina loses her case. I mean, the entire purpose of the Unruh Act comes, assuming that the facts are what we believe them to be, and that Gina can prove them, which strikes me as likely, that there are internal communications that will back up her claim that she was not fired for economics reasons or even artistic reasons, or even for moral reasons, but for political reasons. And that's interesting to seeing how, an intellect like Eugene Volokh threads the needle on the question between moral. We as a corporation have our set of morals, and our set of morals says that if you are the kind of person who is against, illegal immigration, or you're in favor of Doge, or it's morally we're offended by that, and our stockholders, as you know, there's nothing we can do that prevents that will ever make our stockholders not trust us with the governance of this company, and therefore that's the decision that this corporation makes. Why should the state that corporate decision and the stockholders? So these are important issues, and maybe because these issues are going to be dismissed, are going to ultimately be hashed out, even if they don't make a constitutional challenge, they might. I think they're going to be implicated. So here we go.
So the last question I would ask then is a simple one. So would they have to have written down that and presented it to Gina as part of their rules that she has to politically abide by this radical leftist stuff?
You're asking explicit versus implicit, right?
Yeah.
No, because in an at-will employment, the only reason you can't fire someone in an at-will employment situation, and let's abstract from the question of, is it a violation of the at-will employment concept to not renew someone's contract? That's a complicating factor here. On the motion to dismiss, the judge held that was not dispositive. But it is still, the question still is, the issue still is, separate and apart from what might be in a contract, you can fire someone on a basis for any reason that is not prohibited by law. So you can't fire them for being black. You can't fire them for being a woman. In California, you can't fire them for political incorrectness. This is the test of that.
All right, folks, that's where we will leave it for now, but we will continue to follow up with Ron Coleman, who is the expert we need as we get ready to see what many of you have been begging for, dare I say praying for, Kathleen Kennedy somehow associated with the Supreme Court of the United States and not as a justice. The Hollyweirds don't understand how it is we do what we do, bringing you video after video every single day of the utmost highest excellence and quality. But folks, we do it because of you. We appreciate you. You are seen and heard here on the Pro Channel. Make your voices heard, folks, by doing one last thing before we say goodbye for a short time. Consider clicking the like button. Share, subscribe, and you know what? That notification bell, click it and stick it to the algorithms. Also, drop a comment down below and let us know your thoughts. And don't forget, folks, we've got even more content on the way. If you'd like to become a member, it's just the price of a soda per month, and you'll gain access to all kinds of exclusive content beyond what the public sees, including archival footage of the Pro Show that goes away after just a few days from its public release. Folks, we hope we get the honor of spending time with you again soon. And until then, keep learning, keep growing, and as always, keep having fun.
Hey, Floral, guess what?
You put a fork in Pro's microwave again.
No, that was yesterday.
I don't know that what.
Oh, I've decided to give up on torturing Jonas.
What? Why? In the same way the cat sleeps like 20 hours a day, that was like your purpose.
I know, but I've decided there's bigger fish to fry.
Okay.
Like Lorne. I mean, think about it. Everybody loves him. He's a fan favorite, and frankly, he has almost no weaknesses I can find. Except that he's really smart.
So, you want to annoy the one panelist without a single flaw, because he's smart.
Yeah, like that winged statue at that fancy Paris museum thingy. I want to break the one thing that everyone loves most.
Right. So, kind of like the opposite of Rachel Zegler.
Yeah, exactly. And I get to see her all the time at family reunions anyway.
You get to see Rachel Zegler?
Yeah. She's a total troll. Lives under a bridge, harasses billy goats, the whole 9 yards.
It all makes sense now.
Speaking of which, maybe she'll get me... Okay, call her on my... I'm gonna call her and see if she'll be in the next Indiana Jones. She should be the next Indiana Jones. That'll totally destroy Lord. He loves Indiana Jones.
Oh, that's cruel.
Hey, Rach. I've got a cool idea for you that involves a whip and snakes.
I love that description. It's perfect.
I know, right? Weird, as we always say.